Friends, Namaskaram, how are you? Myself is Dr. Jineesh Soni. I am an advocate in a defense council. Har Har Mahadev, Jai Shiv Shambhu. In today's class, I will discuss one of the most important judgment of Honorable Karnataka High Court. In that case, remedy has been inclined to the concerned person who are alleged to be accused in that case. The allegation was regarding the conspiracy, fraud, cheating, and violation of copyright. So basically, if you are having the similar case with a specific allegation, in that scenario, what we can do, what will be our strategy. So I'm going to specify you the things in the easier manner. So directly we are moving on the board. Please maintain a proper notebook with pen or pencil to maintain your information in the proper recorded format. Directly we are moving on the board. So first of all, we will note down the problem. If complainant file a criminal case against us on ground that we inter alia violated the copyright law, BNS means for cheating plus fraud plus misappropriation plus conspiracy. We are having the allegations. In that scenario, there is no need to worry because allegations are not proof. The prosecution has to prove the case beyond reasonable doubt. Regarding this, section 104 of BSA is quite important. I will discuss judgment of Honorable Karnataka High Court. Petition number is 513/2026. In that case, the allegation was against a company and its director. It was concerned with conspiracy plus misappropriation plus fraud plus cheating plus copyright infringement. And it is submitted by the complainant that a loss of rupees 7 crore had been caused. While challenging the entire FIR, it is submitted by the accused persons that the process adopted by the complainant is wrong. Accused submitted that at inception there was a report to the police, but police has not lodged the FIR as per section 154 subclause 1 of CRPC, and finally a complaint had been submitted to the magistrate as per section 156 subclause 3 of CRPC with a prayer to register the FIR. But before making the order, the court has to ascertain whether the allegations are going to constitute a cognizable offense or not. The court cannot act mechanically. And apart from that, the complaint is required to be supported by an affidavit. The views laid down by Honorable Supreme Court in judgment of Priyanka Shrivastava versus State of UP. And apart from that, concerning point number 1 and 3, we are having judgment of Honorable Supreme Court, that is Lalita Kumari versus State of UP. Citation is 2014, Volume 2, SCC, page 1. And apart from that, in judgment of Babu versus State of Karnataka, specification is 2022 SCC online, Supreme Court, page 200. Honorable Supreme Court specified that court, while acting as per the protocol of section 156 subclause 3 of CRPC, cannot act mechanically. So in the present case, it is submitted that a civil dispute is pending between the parties. On the same cause of action, there is a criminal case. There is no affidavit which is mandate, and apart from that, the order is mechanical. So the guidelines laid down by Honorable Supreme Court is violated. The court observed that to constitute criminal breach of trust plus cheating, dishonest intention of the accused must be on record. if the allegation pertains to civil dispute or there is a damage regarding which the remedy lie before the civil court. In that scenario, criminal prosecution will not be maintainable. And apart from that, the criminal breach of trust and cheating are antithesis offense. So the court specified that the criminal law cannot be used as a tool for recovery of money. That is important. So if you are having any grievances that your money is to be refunded and you deserve the compensation, the remedy lie before the concerned civil court. But regarding this, the criminal law cannot be set into motion. That is important. Please be noted. It is called the golden rule. So simply we could say that the criminal law cannot be set into motion as a tool for recovery of money. So basically, if you are having the case of copyright violation against you, ascertain the allegation, give the proper reply to the concerned IO, and if there is any civil suit on same cause of action, the criminal action is brought, you may challenge the FIR before the Honorable High Court. But before that, reply is must. That is called memorandum. So basically, I have specified you the steps in general so that you could put up your rights, so that you could defend as per law. And the said scenario is also requisite to parry any consequence to your right which is given to you by the law. Always remember that we are having Article 21, which says that life and liberty are fundamental rights. If the feds are going to compromise your legal rights in that scenario, you may come forward and inter alia submit your submissions or objections and could avail remedy as per law. So things are easier. It depends upon us in which manner we are going to proceed. See you in the next lecture.